All right. Hello, everybody. How's it going? This is Immigration Attorney Mamita. I'm coming to you live to talk to you about immigration, to see the questions that you may have on your mind tonight. Thank you so much for joining me. My name is Mamita Rahman, and I'm an immigration attorney. I have been practicing immigration law for the past 15 years, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. So thank you for joining me on my platform. It's nice to see everybody. If you are a current client, thank you for trusting us with your case, and also thank you for all of your patience with us as we work through all of these issues with immigration. And also, if you are a new viewer, if you're just a follower, thank you for watching, thank you for following, and I definitely hope that you will find the information that I talk about useful. So go ahead and let me know what questions you have, what your concerns are with immigration. And also, I love to know what country you are from. I myself am from Bangladesh originally, and I came to the US when I was 5. And, it's been a long time. Definitely a lot of things have happened since I came to the US. And I would love to know where you're from and what state you live in, okay? And if you want to call us for a case evaluation, our telephone number is 212-248-7907. Even though we are based in New York City, we work with clients all over the US. So it does not matter to us where you live, as long as you have the sort of case that we can help with. We would love to help you, okay? All right, so let's go ahead and talk about our current questions that we have today. The first question that I want to talk about is there was an updated guidance that came out from USCIS on August 1st that is really making people very, very worried, and it has to do with family-based cases. And for family-based cases, the new guidance that's basically coming out, I'm going to just boil it down to a few simple bullet points to make it very, very easy to digest. I'm not going to talk about everything. But number one, if you are filing for a marriage-based case, a joint case with your spouse, you're filing an I-130 with your spouse and an I-485, the new policy is that, if you have certain warning signs or red flags in your case, then the immigration officer who is looking at your case may automatically send you a notice to appear or may deny your case. Definitely, they're going to call you for an interview, okay? So why does this matter? Well, number one, I think everyone just needs to be prepared for the possibility, no matter what sort of case, if you basically, what it's boiling down to is that immigration is going to do its utmost to make life difficult. But if you are filing a marriage-based case, it's more important than ever to make sure that your case gets properly filed, to make sure that you are prepared for any issues in your case, and that you work within a law firm that knows how to represent people really strongly in front of immigration officers. And I'm really pleased to announce that we are accepting marriage-based cases right now. Definitely, we need to evaluate your case to make sure there's no warning factors and then go over any pros and cons. So give us a call if you want to schedule the case evaluation for that, for your marriage-based case, 212-248-7907. Now, next, the other question that I have been getting for this is, does this new guidance apply to VAWA cases or to T visa cases? And the answer is not exactly, it does not, because if you look at the section of the USCIS policy manual that this affects, it is strictly for family-based applications. And family-based applications is going to be for I-130s, because there's a totally separate section in the USCIS policy manual for VAWA cases. Those sort of cases, they have to be processed very differently. Number one, the I-130 is decided by an immigration officer at the field office level, but a VAWA case, an I-360 application, is actually decided at the service center, okay? They are decided by specially trained officers, although these specially trained officers tend to be a little bit newer now, so we're getting lots of requests for evidence, but they're not decided by officers that do active interviews, okay? So that's the second question that I've been getting about the new guidance that came out from USCIS regarding the family-based petitions. So main takeaway for you is that if you are filing a joint case, your spouse is helping you file, you're filing an I-130 together with your spouse, now is not the time to do it alone. You want to be working with attorneys who can assess your case properly, who can look for the red flags and prepare you well and represent you well at your interview, okay? 212-248-7907. All right, Dina Hussein is asking any updates for I-751 VAWA. Dina, yes, actually here are my biggest updates to give you if you are needing to file an I-751 application in order to remove conditions on your application. So again, An I-751, if you got your green card already through your U.S. citizen spouse, and you did not yet reach 2 years of marriage when you got approved, immigration is automatically going to give you a 2-year conditional card. And the reason why it's a conditional card is because mainly they want, because you haven't been married for that long, when they approve, they want to make you jump through another hoop to have you prove that your marriage is real. Okay, that's why they give you only a 2-year card. And what will happen is you have to file another application. So you do all of this work to get your green card. You go through all the expense and the fees. And then what do? They make you do another application before the card expires, right? This application is called the I-751. And guess what? You still need your spouse to help you file, right? So what happens though, if your spouse is, marriages don't always work out. Marriages don't always work out, and your spouse may not be treating you well, and they may not want to help you file any longer. Maybe they told you that they're going to divorce you. Maybe you have had to move out, or maybe your spouse is hurting you and is trying to control your life so that you can't really ask them very easily for their help on your removal of conditions application. So what happens is, if you cannot file with your spouse, if you're no longer together with your spouse, you may be able to request a waiver. And there's a few types of waivers, but the two most common waivers that you can file for, where you request to waive your husband or wife petitioning for you a second time, is going to be a waiver for divorce or a waiver for extreme cruelty or battery. And for the waiver for divorce, you need to be actually divorced. If you're just separated from your spouse, if you don't have your final divorce certificate, then this is not going to work. So if that's not an option for you, because maybe your spouse walked out on you, maybe you can't complete the divorce process, right? What happens then? Well, if your spouse walked out on you, or you can't complete your divorce, something else is happening, then we want to look to see if something happened during your marriage where your spouse was controlling, manipulative, they were hurting you emotionally or hurting you physically or taking advantage of you in some sort of way. Because if those are the case, then you may qualify for a waiver based upon extreme cruelty and battery. And that is what Dina here is asking me about updates about the I-751 VAWA. And my update is that, first of all, if you're filing an I-751, for the most part, almost everyone is being requested for an interview for the I-751. Now, we are still getting approvals for many clients for whom we filed the I-751 based upon a waiver, who are not getting a request for an interview. However, we are also getting lots of requests for interviews, and we do a lot of these in our office. Maybe we're one of the few law firms in the country that files so many I-751s, I don't know, but we're getting, I would say, about 75% of the cases are getting interviews, and another 25% are not getting interviews, and they're still getting approved, okay? But if you have filed an I-751, you should reasonably expect that you might get an appointment to show up. And what are these interviews like? Well, they vary across the board. Sometimes they're short interviews, sometimes they're long interviews, sometimes they're good interviews, sometimes they're bad interviews. And that's another topic that I'll talk about another time. Do check me out on YouTube, because I have videos about this, okay? So Dina, my biggest update for I-751 VAWA cases of requesting the VAWA waiver or the waiver for extreme cruelty and battery is, number one, be prepared to receive an interview notice. Number two, it's still taking pretty long. Like a joint case will take about 2 years, and as will a case with a waiver, maybe 2 to 3 years, okay? And if you need help, if you're in the situation where you have a 2-year card that is about to expire, or maybe your 2-year card is already expired, it is time to give us a call, because you do not want to be stuck. If you have a 2-year card and it's expired, you have the option to do something about it. You're in a much better position than a lot of other people. And we have helped people with their I-751s whose cards were about to expire, whose cards were already expired, who have already received orders of deportation because other attorneys filed an I-751 for them and did not do a good job. So these are things that we have helped people with. We have worked on cases where there was no evidence at all. I like to share the story of how I helped my client from Pakistan get approved for his 10-year card after he was already denied before, after he already got sent to immigration court, and after we had to bring it back And all we had in his case was a psychological evaluation, essentially, okay? And we eventually got it approved, okay? 212-248-7907. Okay. Emerson, hello. Hey, Emerson. What do you think about asking congressmen to inquire about on your behalf about the cases taking too long? Emerson, I definitely think it could help. I think really the only way to get help these days, if you want to expedite your case, is really going to be to inquire to get the assistance from a congressional representative. Now, then it's going to depend on how seriously they take their constituents, right? Because I think in some states, they are helpful and in others they're not. But if you're worried about that, I think it's definitely worth looking into. And give us a call about that, Emerson, okay? KK, can you still file a T visa if you receive an NTA? KK, yes, you can. So a lot of you out here are going to be receiving notices to appear in court because at this point, USCIS is sending notices to appear in court, even for cases that were denied years ago. So do not be surprised that if you try to file something, 2, 3, 4, 5 years ago and it did not get approved, that now you're all of a sudden getting a request to appear in court. So what can you do if you get a request to appear in court? Well, number one, you still have to defend yourself, okay? You still have to figure out what you can file in court to see how you can protect yourself. But number two, there might still be options for you that exist outside of court, such as a VAWA or a T visa or a U visa. Now, the courts may not, hey, Nick, thank you for the heart. The judge, for U visas are taking a very, very long time. And a judge may not, be willing to wait to give a decision on your case until your U visa is approved. But other cases like VAWAs and Ts, probably they would take, about 3 to 4 years, 2 to 4 years, depending on which type of case that you do. And, by the time you have your final hearing in court, you might even have it approved before an individual hearing date. So you can still apply. Having a notice to appear does not prevent people from being able to file for these sort of cases. And it can definitely very much help, especially if you get approved. You may be able to go to the judge and get a termination. You may be able to go to the judge and get a continuance. There's a lot of ways that this can help. And generally speaking, judges like to see that you have something in process. I believe for me, in my opinion, it makes judges a little bit more sympathetic. Of course, it's not a guarantee that they're going to approve or terminate, but it can definitely help. Okay. So KK, thank you for that question. Thank you everybody for all the gifts here on TikTok. Nick, thank you so much. Nick, I don't know if you gave me a question or not. Noli, how long for work permit after biometric appointment on T visa from Noli? Noli, so it depends, when you're filing for a T visa, there's 2 types of work permits. One is called a bona fide determination work permit, and the second is going to be basically the work permit upon approval of the T visa. Now, I do want to caution everybody that even though there was this exciting news that USCIS is giving out work permits for bona fide determinations on a T visa, in reality, they're not really giving out a lot of these. And we have seen very few come out in our office. So as far as how long it would take, Noli, I don't know anymore because we haven't seen any come through. Also, USCIS has been so late on even giving receipts, and I'm sure that's definitely going to mess things up as well. Candace, thank you for that. Candace, I don't see a question from you. Okay, I had some questions here. Would a tourist visa overstay affect the marriage case? No other kind of record. From Pawanda. I just had 2 green cards approved from interviews last week or the week before, where both of my clients were overstays. One overstayed for about 20 years. He got approved. It wasn't an issue. However, it's always going to boil down to the type of officer you get in your case. Generally speaking, if you are doing an I-130 and you're married to a United States citizen, if you're a visa overstay, generally speaking, at least in the past, it's never been a problem. But definitely give us a call, 212-248-7907. Let's see. From Jose Juan. Let's see what your question is, Jose. Juan Jose. Soy mexicano y llevo desde 2009 y tengo récord impeccable y creo que pueda arreglar papeles desde Jose Juan. Y Jose Juan, voy a voy a contestar en español y mi español es un poco malo, pero sí ha entrado. Ok, José, no tengo mucha información sobre su caso, porque si una persona pueda arreglar depende en varias cosas. Por ejemplo, en cuál manera usted, en cuál tipo de manera es su entrada a este país. También necesito saber si tiene algunos familiares que puede tramitar una aplicación para usted, o, por ejemplo, depende si usted califica para otros tipos de casos humanitarios, ¿ok? José, puede llamarnos al 212-248-7997, ¿ok? The Alia Ross. Okay, I'm pinning my number right now. Sorry, guys, I do this by myself, and I always forget to do that. 248-7907. Okay, phone number is pinned. Okay. Diana Alyad, your team is late for applying my case for 2 months. Diana, I think we've informed every client that we're experiencing delays and we're having a backlog in the way that we process our case for a multiple of reasons. But give us a call so we can talk about this, okay? 212-248-7907. It's not an ideal position, but we've been put in a very difficult spot because of all the changes that USCIS is forcing upon us. Okay, so let's see. Hello, YouTube. Thank you for waiting for me to look at your questions. Ambi is asking, good evening. I filed VAWA with your firm in 23 and divorced in August 23. My divorce will hit 2 years soon and VAWA in October 2025. I also have 2 prima facie, no results yet. Should I be concerned from Ambi? Ambi, no. Ambi, thank you. First of all, thank you for being a client and for, of course, for being patient throughout this process. If you already filed for VAWA in 2023, first of all, the fact that you've gotten divorced should not affect your case because you already submitted your application. Now, it's been about 2 years, more or less, since you filed your case. And should you be concerned if you filed your VAWA application, it's been 2 years? The answer is no, because in reality, a VAWA case, typically, before this year was taking about 3 years. But now that wait time, I'm sorry to say that the wait time for seeing approvals is now stretching into 4 years for a lot of cases. So Ambi, the best thing I could say is that, I know it's been a long time. You still have, at least 1, maybe 2 more years to wait for a decision from immigration. And the truth is, guys, we don't know how much worse wait times are going to become with immigration because, there's so much junk happening right now, right? They're firing people, they're slowing down processes, they're changing rules, they're making us resubmit things. They're forcing their officers to do extra work like issuing NTAs. One of the interviews that I went to a couple of weeks ago for a client, I chatted with the immigration officer and he told me that, it takes about 2 hours per case for an officer to write and notice to appear. 2 hours is a lot of time. And, if they're going to be clogging up their own work by requiring officers to do this for cases that get denied, then everything is going to slow down. Everything has already slowed down. So the best advice that I could give to anybody who has filed an immigration case and is worried about how long it's taking to get a decision is that, number one, you need to prepare yourself mentally, emotionally, physically, however you can to wait for a long time and to live, I don't like to make anyone feel this way, but you have to get comfortable with living with that degree of uncertainty about not knowing a specific date upon which you'll get a decision, okay? So I hope that helps, Ambi, but the great news is that, it sounds like you're more than halfway done with your wait, okay? That's the positive news that I would think about. Can you get a green card approval with DACA from El Blanco? El Blanco, can you get a green card approval with DACA? The answer is it depends, right? It depends, because if you have DACA, it doesn't matter that you have DACA. What we actually have to look at is to see how you entered the United States, because the reality is that majority of people who have DACA may not have entered the United States with a visa entry. And if you don't have a visa entry, that's where things become more difficult. So for my DACA clients who do not have a visa entry, who do not have a admission into the United States and were brought here through the border when they were younger, what I recommend is for them to get advanced parole. And if you have DACA, if your DACA is not expired and you have a reason to apply for advanced parole, I encourage you to do it now before they take it away. Because once they take away advanced parole, we're probably not going to get it back for God knows how long. Okay. So, and it's, it's obviously, it's something that you have to think about whether it's okay for you to travel outside of the US to do your DACA advanced parole stamp. But that's an option, because once you have the stamp, it makes it much easier to file a one-step process with an I-485 and fix your status in the country without leaving, okay? Give us a call, 212-248-7907. I'd love to see if we could help you with that. Thank you for the follows, everybody. Zoha is asking, should I go and take a divorce before a VAWA result? It's been 4 years waiting for the case result, from Zoha. Zoha, that's really a personal question that you have to figure out for yourself. Now, if you have already filed your VAWA case, getting a divorce should not affect it. But of course, if you get denied and your divorce is past the 2-year deadline, then you may not be able to file for VAWA a second time. And you're going to hear conflicting information or conflicting opinions about this, because some attorneys will say, no, don't get divorced at all until you get your VAWA approved, which is fine. But also you have to think about, what do you need to move on with your life? Because having an unfinished divorce or an unfinished relationship that you're no longer in, it's a mental burden, and a lot of people don't want that. So what we do is we tell our clients, do what is best for you. If it makes you happier to get a divorce, if you get that peace of mind, then you deserve that and you should do it. On the other hand, a lot of people do not want to go to court. They don't want to deal with the divorce. They don't want to fill out paperwork. And if that's the case, then we tell clients, well, if you don't want a divorce, that's okay. It's up to you. The bottom line is that if you are doing a VAWA self-petition, one of the things that I advocate for the most is I want, for my clients and anyone else who is looking into VAWA, even if you're not my client, I want you, to have a happy life. You deserve that, after everything that you've been through, you deserve that. So you get to pick your adventure for that. Okay. So is it advisable to get a divorce? Really, you have to decide that for yourself. And of course, if you have an attorney, speak with your attorney, get their opinion, and then make your decision accordingly. Okay. Miriam's asking, does VAWA protect me from ICE? My marriage-based green card was denied on April. The letter said I overstayed. Can I continue working until I get a work permit through VAWA? From Mariam. Mariam, okay, so this is actually for anyone, technically, if you did a joint marriage case that already got denied and you already have a work permit through it, the minute that your I-485 gets denied, it technically ends your ability or your technical right to use the work permit. So that's the most that I will say. Whether you decide to use it or not is, kind of like your decision, I guess. Now, will VAWA protect you from ICE? The truth is that ICE is targeting everybody these days, even US citizens, even green card holders. They're targeting anyone who looks brown. So nothing can prevent anyone from getting arrested by ICE. Unfortunately, that's the tough news these days. But when you have a case in process, it gives you more protection, more things to talk about with the judge, more ways to show that you're trying to fix your status the right way. Okay. So something is better than nothing, in my opinion. And that's really what you have to focus on, because the unfortunate reality is that this current government is pretty lawless right now. So we don't know what's gonna protect, if an ICE agent is gonna, care about what you have in process. But if you do get arrested, you have more ammunition to protect yourself in that case. Okay, 212-248-7907. All right, guys. I have to go. I hope this was useful. If you found my video to be useful, then please do me a favor. I really appreciate you sharing my video with anyone that you think it might help, okay? You never know when someone's life can be changed as a result, okay? And again, my name is Mamita Rahman. It's been my pleasure to be here with you today. Have a good night and God bless.